Them Zaga, Zen.
From every whisper to every commotion.
That's rubbish. The KSAMC cannot investigate itself.
Was Click News really talking like that?
Every news story unfolds here first at Nationwide 90 FM, the new revolution in media. Every sound is a story, and every story we share is news.
Tune in to our program live from our YouTube channel, Nationwide 90 FM. And remember to like, subscribe, and share our content. And we're also on WhatsApp at 876-285-5693.
The people's champion. Our mission is love. Our vision is love. Jamaicans for justice. The people's champion. Justice, justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Justice, justice for all. Justice under the law. Justice, the people demand. Right to life and security. Oh, what a joy. Oh, what a peace. How great this country could be. Respecting your rights. Respecting human rights. What a wonderful nation this could be. Out of many we are one in a Jamaica. Make it a better place for the boys.
Happy Monday, and welcome to another episode of Let's Start Justice with the JFJ team. My name is Michael Jackson, Executive Director of JFJ.
And I'm Jade Williams, the Policy and Advocacy Specialist at JFJ.
Now, we're going to be discussing a matter of national importance. Well, we normally do, but this is an area I hope that people would recognize the importance of having dialogue on where we are with the Access to Information Tribunal. And we're going to be joined by several people this week. Andre Earl, King's Counsel, Attorney at Law. Diana Macaulay, founder of Jamaica Environment Trust and quite active activist just the same. Daniel Andrade Goff, who's also an attorney at law. So we're going to be having that conversation in short order. But before we do, there are just some matters I want us to touch on briefly based on some news items coming out of last week. Now, we heard that Indicom is investigating three deaths following three deaths that occurred in police lockups. One was on September 19th in Portland. Then the other two occurred September 23 and 29 at the Halfway Tree police station. And it's of concern for us here at JFJ because we have flagged the issue of the state of police lockup in our country when we look at the inhumane conditions that people have been detained. When we look at prison overcrowding, lockup overcrowding in our country, it is something that we have impressed upon the Minister of National Security over the years to deal with. So I think as Indicom investigates and we await the outcome of that investigation, I think it's still important, Jade listeners, to have a little bit of a concern there. I know some people are listening in and say, what do you want? Bed of roses and so on. No. Remember, any one of us can come in conflict with the law. You can be driving on the road and you are charged with a particular road traffic offense based on how you respond. We have seen where, for simple matters, people have been detained at the police lockup. Yeah? And with that in mind, I think we have to ensure that certain standards are met when we look at these facilities. And again, 3 deaths have resulted here. So we await the outcome, but I think we have to impress upon the National Security Minister to address this long-standing issue.
You know, I think also as we talk about, the conditions of lockups and prison overcrowding in particular, we have to remember that improving these conditions will not just improve the quality of the stay for the prisoner, but will also improve the quality of the work of the guard.
Exactly.
Who is expected to oversee way more than should be prisoners in each of these facilities. So it's important that we address it both from a safety and security issue as well as a human rights issue.
Yes. The second thing, Jade listeners, that I want us to touch on that happened last week, and we saw an article in the Jamaica Gleaner that says we will not cower. And that was a word used by the commissioner, the chair of the Integrity Commission, retired Justice Seymour Panton, because the Integrity Commission, its officers, in particular the Director of Investigation in recent times, we have seen some comments on social media that are concerning. Some of them are derogatory comments, some of them are menacing, and a few we believe would be quite threatening. And when there is an insinuation or overt statement that you have officers who are politically aligned, it will be a cause for concern, because you're bringing people's reputation into question without any reason for that. We have heard comments in the House of Parliament from government ministers that are quite concerning, because some of those comments have also brought into question the reputation of some of the officers at the Integrity Commission. And one could argue that it may influence the political supporters to make unworthy comments towards the officers of the Integrity Commission. And we stand in support with the Integrity Commission in that respect. And we make it very clear here at JFJ that while the Integrity Commission, they are not beyond criticism, and they should be critiqued as we hold them to account, certainly, we don't believe that any officer who is carrying out their lawful duties should be subjected to derogatory comments that are menacing or threatening. And I think that is where we have to draw the line as a country, as people remain independent and carry out their duties without fear or favor. Yeah? Over to you, Jade.
Thank you for that, Mikhail. All right, so as we said when we started the show, we are talking today about our right to know, and topically on the Access to Information Tribunal. But before we do that, we'll give you our Did You Know, not a right of the day this week, a Did You Know and our trivia question for today. So our Did You Know comes from the Access to Information Act, and it is Section 6, which speaks to your right to access. So it states that each person has the right to obtain access to official documents, and that means those documents that are held by public authorities, that there are some documents that may be exempt from disclosure, and there are specific reasons in the legislation for why they might be exempt. And also the application process that you would go through is contained in Section 6. Now, it states that for you to get access to that official document, you should not be required to give any reason to get that access, because it is public information. And as you are the public, it is your right to know that information. So that's your Access to Information Act, Section 6. Now, our trivia question for today is also related to the Access to Information Act. And it asks, how often should the Access to Information Act be reviewed? So that is a section in the legislation that speaks to how often Parliament should look at the provisions in the Act. So if you can tell us what section that is, you'll win our trivia for today. So you can respond in the chat on Nationwide YouTube, or you can respond to 239-7583, or on our Instagram, JA for Justice.
All right, perfect. Did, and I really do think I'm going to set a clear instructions. We need to increase the amount of money we're giving away for credit. It's $500. We need to increase it to $1,000. That's so, producer, Miss Vanessa, it's $1,000 credit going forward. You can't give people these bright questions, stressing out their brains and so on for $500. All right?
Wow.
So let's increase the amount. But let's get into the meat of the matter for this week. So, Jade, your right to know, very, very important constitutional right that we have here in Jamaica. And under Section 32 of the Access to Information Act, citizens do have the right to appeal when denied access to information after an internal review has taken place. However, as reported by the Sunday Gleaner on September 12, the Appeals Tribunal, which is quite critical to this process, has been inactive since February of 2024. The tribunal is to be composed of 5 members appointed by the Governor General after consultation with the Prime Minister and the Leader of the Opposition, and that is also according to the second schedule of the ATI Act.
Now, without the tribunal, it was reported that there are nearly 20 appeals that are currently in limbo, and that would significantly infringe on the right that we just discussed to access that information. Now, the tribunal is essential for ensuring transparency and upholding that right to access. And while the mechanism is missing, it obstructs justice, but also erodes trust in the system that we have.
Now, according to Attorney at Law Andre Earl, he highlighted that the absence of this tribunal has left his client unable to challenge a decision where information was excessively redacted without explanation. I also had the opportunity to listen to Susan Goff, one of our founding members, if you will, and current activist just the same. And she indicated that she has also submitted several appeal requests, and it's nearing, I think, some 5 years, if my recollection is correct, that the matters have been placed before the Access to Information Tribunal. So there's some cause for concern, but since that Gleaner article highlighting the lapse, the Minister of Information, Dr. Dana Morris Dixon, Senator, she has indicated that the process was underway to reconvene the tribunal, but unfortunately she gave no expected date for this process to be completed.
So I believe we have a clip from Senator Dixon. Okay. All right. So we are already joined by Mrs. I'm sorry,
Attorney
Daniel
at Law,
Andrade
yes.
Goff, Attorney at Law, and we're also joined by Miss Diana Macaulay, founder of Jamaica Environment Trust. We're still waiting on Mr. Earl to join us. But welcome, ladies. Thank you for joining.
Thank you. Thanks for having us.
Good afternoon.
Good afternoon. Thank you.
Okay, so I'll start with you, Mrs. Goff. If you can just give us a general idea of your experience with the Access to Information Tribunal. What was that process like for you?
All right. I've been involved in a number of appeals using the Access to Information Act, where persons or organizations have sought to obtain information from various public authorities and have been denied or sometimes ignored, in terms of their request for information. And as a result, I have represented them in bringing appeals before the tribunal. The tribunal serves a very important role. It's a quasi-judicial body. It's a body which was set up under the Access to Information Act and ensures that those persons who are unable to obtain information have some sort of avenue or path to do so without having to go to court. In fact, the law says you don't even need an attorney to appear before the tribunal because it's supposed to be this accessible, affordable mechanism for justice. In reality, there are some challenges. So I find that the process is very legalistic, and oftentimes I think it is made so because, one, the statute itself requires certain things to be done as part of the process in filing an appeal, stating your grounds of appeal, stating, the errors of the law that have been breached.
So you don't need an attorney, but the process itself almost dictates it.
It necessitates, right,
Yes.
It necessitates some amount of legal understanding. Of course, I think the government has tried to navigate that by having an Access to Information unit to support persons, to provide them with assistance in bringing an appeal. But the reality is that there is this process that has to be undertaken, and when you are challenging a decision by a public authority, you best believe that that public authority is going to be represented by an attorney, oftentimes the Attorney General Chamber, somebody from that department. So I have found it something that, I would love to see that being addressed, to have a process that is more simplified for persons to be able to bring appeal before the Access Information Tribunal. I think, one of the challenges that has happened
Mrs.
in the
Goff,
past.
I'm going to ask you to pause right there. We're going to take the break. When we pick up, you can tell us about that challenge, and then we'll pick up with Mr. Earl.
Okay.
Live exquisite this year with new arrival black and chrome fixtures for your home at Unique Living. Select from a wide variety of rain shower systems, fabulous faucets, and stylish sinks to suit your kitchen and bathrooms. Get uncompromised quality and style unique to you. Shop everything new at Unique Living, Jamaica's leading shower and faucets provider. Visit shop number 6, 30 Dunrobin Avenue, Kingston 10, or call 876-755-3661-2.
Escape to the tranquility of Spur Tree HomeAway Villas, a placid getaway featuring 3 unique accommodations. The spacious main house offers 6 aesthetically pleasing designed bedrooms, 3.5 baths, smart lock access, and modern amenities like smart TVs. Enjoy the cozy 2-bedroom suite with private baths, or retreat to the intimate 1-bedroom suite. Relax by the pool or explore Spur Tree HomeAway Villas. Book with us today. Contact 347-307-3732 or 646-824-5232.
Welcome back to Let's Talk Justice. We're discussing your right to know, the access to information tribunal. Mrs. Goff, I'm just going to ask you to finish your thought that you were making before the break there.
Sure. I mean, I was just speaking about the challenges, but not to belabor the time. I just wanted to highlight that they play a very important role and function in supporting people's rights to obtain information. So we really do need to have a functioning access to information tribunal. That is essential.
Thank you, Mrs. Goff. So, as you say, functional, that brings me straight to Mr. Earl, because this discovery that the tribunal was not in place actually came from access that your client was trying to get. So, could you give us a little bit of context about that and what you were able to find out about the tribunal through that?
I would be happy to. Good afternoon, everyone.
Good afternoon.
And good afternoon, dear listeners. And let me commend you on the great work which you have been doing. In terms of the situation with my client, an appeal had been filed on behalf of the client in July of this year. And when I made inquiries of the Access to Information Appeal Tribunal Secretariat, I was told that there were a number of appeals ahead of mine and that there was no person, there was no body in place, constituted tribunal in place. And I said, why is that? How long has this been the case? And then I did some research and found out that that has in fact been the case since actually February of 2024. And remember, I made this inquiry in July. So that prompted my firm to write a letter on the 29th of July to the Honorable Minister responsible for information, Dr. Dana Morris Dixon, and asked for this tribunal to be appointed as soon as possible. There was no response, no formal response. That prompted a second letter on August 12th. And again, there was no formal response.
So
We
you
did
use the
get a
word Mr.
telephone
Earl.
call.
My apologies. Just for clarity.
Formal as in written. Formal
Yes,
as in written.
but you got something else otherwise, informally or otherwise?
We did get a telephone call
Okay.
from someone who identified himself as working in the minister's office and indicating pretty much that the matter was being dealt with,
Ah.
which of course I found completely unsatisfactory.
Yes.
And so a third letter was written, and that is on the 11th of September. It was sent by email to the Honorable Minister on the 11th of September. And we pretty much said in that letter that to date we have not received a substantive response from your office, aside from a verbal communication from, and we indicated the name of the technical assistant who had contacted us, who acknowledged receipt of our letter and indicated that a response was forthcoming. However, no further communication has been received. We must advise that if this matter remains unresolved, we'll be compelled to escalate it, if necessary, via the courts, as our clients' rights are being significantly infringed. We can request your prompt attention here. We sent a copy of that letter to the senior director at the Access to Information Unit, to the then president of the Press Association of Jamaica. We also sent a copy to the permanent secretary, the Honorable Rocky Mead,
Yes.
in that particular ministry. And then, remember I told you that that letter is dated September 11 from my office.
Yes.
We got a letter the following day, September 12, via email, but dated September 10. I wonder if you're following.
Yes.
My letter from my office is dated September 11, was dispatched on September 11 via email. We got a response dated September 10, but received it on September 12 via email from the minister's office. And that letter pretty much said, I'm writing to inform you that the Access to Information Appeal Tribunal will be officially reconstituted in short order. The matter is being prepared to be brought before the Cabinet to seek its approval. The government is committed to ensuring that the tribunal is adequately equipped and staffed with individuals who possess the requisite expertise and integrity to handle appeals effectively. Further details regarding the specific date of the establishment of the tribunal will be communicated in due course. I appreciate your patience as we work towards properly establishing this critical institution. So that's what that letter said. So my major problem is the following, or problems are the following. One, why has it taken so long for a tribunal to be appointed? Remember I told you it expired, the tenure of the previous tribunal expired at the end of February 2024. Why has it taken several months for us to hear that moves are now being put in place to get this tribunal appointed? I don't understand that. And secondly, where's the apology?
Yes.
Where's the apology? Ministers, I regard the ministers as our servants. I remember one Prime Minister, Honorable Bruce Golding, when he became Prime Minister, actually described himself as the chief servant. Mm-hmm. So, where's the apology?
Yes.
And I'm not talking to me, not to Andre, or where's the apology to the nation?
Yes, yes.
That you have not done that. And in the meantime, you have, I am the 20th appeal. Mm-hmm. Mm-hmm. Number 20. So you have a situation where today is the 30th of September. I am not aware that a tribunal has yet been formally constituted, but let's assume for the purposes of this discussion that one has been formally constituted. What you then have is a situation where with just October, November, and December remaining, it's impossible for any tribunal to dispose of 20 appeals in that time.
Mm-hmm.
Because you're talking about coordinating dates for the appeal hearing, And there are 5 members who sit on the tribunal. You have my client and me, that's 7. And then you have whoever is representing the institution that I am going against and their attorney. So you're talking about 9. And you're talking about trying to coordinate 9 diaries. That's why it's going to take a long time.
And we've heard from Susan Goff and another interview you were both on, saying that it has been several years for her. But let us bring in Diana Macaulay, Mr. Earl. Ms. Macaulay, you've heard the comments, in particular from Mr. Earl, indicating his experience, is his experience with the appeal tribunal. Having listened to him and utilized the ATI Act before, what are some of the concerns that you have, with this development?
Okay, so hi everybody again. So my involvement with the ATI Act, was from the very beginning. So it spans, I guess, 2 decades or so. And so it has not always been the same throughout that length of time. Obviously, the failure to convene the appeals tribunal is disgraceful and should not have happened. I have generally found that the attention being paid to the Access to Information Act has been spotty. Mm-hmm. The requirements of the law are sometimes met and sometimes not met. And so the statement that was read out from one of the minister's emails or letters that the government is fully committed to the act, I don't think their actions really confirm that they're fully committed to the act. They say that at every possible opportunity, but what actually happens on the ground is something different. Mm-hmm. I completely agree with Danielle about the legalistic nature of the appeals tribunal. I mean, when I was working at JET, and we use the Access to Information Act a lot, we would have been unable to proceed to appeal without having her help as an attorney. Yes. And so it is not an accessible process to the average person. Yeah. So I definitely agree with that. I really dislike this kind of, yes, we passed a law, but we don't really have to adhere to it. I think the law requires, Danielle can correct me if I'm wrong, Michael, you can correct me too, I think the law requires a review. After, I think it was 5 years or so, the review was done. I don't think it has ever been put in place. So, and we hear more assurances of commitment, but I really want to see the actions that are taken to support that commitment. The other thing I would say is my experience in using the ATI Act and the tribunal, and this is a point to be made to the general public, the legal fraternity. The more you use it, is the more the state agencies begin to put in place the staff to deal with the request, right? The less you use it is the less those facilities or those resources are in place. So one of the ensuring lessons I took from my time at JET was the law is a powerful tool, but only if you pick it up and use it. So those agencies at JET did a lot of access to information requests too frequently. We started to get responses more quickly and more completely. Those agencies where they were not used to getting them, you would be ignored for a long time. None of the requirements in the Act would be met. So it really showed me that if this is a right that the public has, and if they want it to actually be operationalized, we all have to commit to using the Act more frequently, and if there's processes like the appeals tribunal. I will say I remember, and maybe Danielle remembers as well, that on one occasion at least, the appeals tribunal sat at the conference center and was therefore able to get through a number of appeals in a day. Danielle, you remember that?
Yes, yes, I recall.
So I think there's ways to deal with the scheduling obstacles that Mr. Earl has well outlined if we're really serious about it. But the fact that they have 20 appeals backed up is very disturbing to me and does not speak to being fully committed to the Access to Information Act.
Spanning 5 years. Daniel, can you remind me quickly before we get to the break? Did we ever finalize the appeal with the Armadale issue?
Yes, so in that case...
I'm going to ask you to hold the response. Let us take the break, and I ask you just to remind us of that, and we go through quickly on it, and then we pick up with some of the other questions.
At the Jamaica Customs Agency, we care for our employees, customers, stakeholders, citizens, and our country. Customs cares. The temperature by the Jamaica Customs Agency is
30 degrees Celsius here in Kingston and 29 out west in Montego Bay.
You ever hear earthquake call and say, "Hello, Miss Lee, yes, it's me, earthquake, I come in Tuesday around 10? No, sir. Earthquake does arrive unannounced, and when it come, it shake all sense and sensibility out of we. Remain calm, stay inside, and do the DCH. Drop, hover, hold on. Once the shaking starts, you know it's earthquake. Make a quick move to a safe place. Don't run to the door, we are in the exit. Stairs might block up or full of people. Elevator, avoid that, because you might get in and poof, power gone, and you're stuck in that box without ear. Drop, cover, hold on.
A message from the Office of Disaster Preparedness and Emergency Management.
Welcome back to Let's Start Justice. You know, before we bring in our guest back, and Daniel, you were answering a question on the Armadale situation. You know, comments are coming in on the YouTube platform and also via WhatsApp saying, why are we focusing on this? And I just want to use a few seconds to explain to listeners that you have a constitutional right to seek and receive information. This particular constitutional right allows you to keep your government accountable, keep your public officials accountable. What is happening in the National Housing Trust? What is happening in any particular state agency? How are you ensuring that some of the promises that were met each time our parliamentarians meet are actually being upheld? So I want to respond directly to a question. This is not a middle class issue. This is not an issue of the intelligentsia, so to speak, or an issue of civil society. This is a constitutional right given to every single Jamaican citizen that we can hold our governments to account to ensure that what was promised is actually being actioned. But beyond being actioned, is being actioned effectively. And that is why we have it. And then if it is that the governments or the public agencies do not respond to us in the timeline within which the ATI Act, the 30-day period, or when they respond, they redact the page, so it's pure black mark you see on the page so you can't read anything, then we have an opportunity now, as set out in law, to go before the tribunal and say this was not fulsomely responded to, or it was not responded to at all. So this is a tool that we can utilize as Jamaican citizens to hold our governments to account. So I just wanted to put that in context, that when we utilize the Access to Information Act, and Daniel is going to walk us through very quickly the Armadale situation. If you remember that fire where several girls were killed in the state home, then you can get a sense of the importance of the ATI Act. Based on Daniel just running us through quickly, what was the Armadale situation and the experience with the appeal process there? Daniel?
Right. So as you mentioned, what had happened at Armadale Juvenile Correctional Center for girls was a tragedy. There was a fire, and it said in 2009, 7 girls had died, and several others were injured and obviously traumatized by the incident. What followed was a 2009 Commission of Inquiry into allegations that the fire was started by a police officer who attended the scene. So it was something that was of national importance for obvious reasons. In this particular situation, an applicant was seeking information. They made a request to get, among other things, the report on the Commission of Inquiry, which they could not find, if you would believe it. The only version of the Commission of Inquiry's report that was available was posted on a website by an actual citizen, and it was incomplete. Nowhere could you find a report from the Commission of Inquiry into this incident. It led him into making several requests to different public authorities, not being able to receive a full, complete version of the Commission of Inquiry. In some cases, his requests were denied for reasons that they said some of the information in the documents related to staff members' personal information, or it would be defamatory if it was disclosed. And in some cases, he was just ignored. And so in 2017, I believe that filed an appeal for the Access to Information Tribunal, and several agencies were involved in the appeal. I think it was about 6 of them, because he had made requests to a number of different agencies. And it went on for quite a while. I think it went on for about 4 years, the appeal process. And eventually the Access to Information Tribunal ruled that the exemptions were not applicable. They specifically held that what those staff members did and disciplinary measures taken against them were things that related not to their personal affairs, but actually to their duties as in their capacity and performance as officials of the state and agents of the state, and so the information could be disclosed. There was a series of back and forth between the legal team and legal team for the applicant and the legal team for the Attorney General's chambers in disclosing a myriad of information, months of back and forth about it. And to answer your question, if every single thing that was requested was disclosed, I will say to you a lot was disclosed, but I think it's the applicant who would have to tell you if he was actually satisfied, if he received everything that would have fulfilled his request.
Okay, thank you.
And I think just to say that, it goes back to one of the things that Dan had mentioned, which is the poor record keeping. The fact that, you had to struggle to get information on something that was so important is really mind-boggling.
Yes.
Shouldn't happen. Not in this.
And we're having our own, we utilize the ATI Act at JFJ a lot as well. And as you mentioned, the poor record keeping, you ask for information and you hear that it's not something that we're collecting. And then it really raises the red flag on how are we monitoring these programs of the government, that we're flagging as a success, but we don't have the key indicators.
Yes, because can I say just one thing? There's an opportunity that we have here, which is that, I don't know if it was mentioned before, but the government has subscribed to the Open Government Partnership, which is this process where governments across the world can voluntarily decide they're going to make these commitments to the people to have a more transparent government. And Jamaica signed up to this process, and they created an action plan, a 2-year action plan, to say we're going to do these certain actions that are going to make the government more transparent. And one of the things they have committed to do is to reform the Access to Information Act. So there's an opportunity here for that review that has been long awaited and long standing to be done, but also for the citizens to get involved in the process in addressing some of the issues with the operation of the Act, to making it more progressive, to making it work better for people. And I think we need to be very careful as well, and that we're very involved in this process, whatever consultations that come up in this process, because you do not want it to be a regression in terms of what the Access to Information Act now provides for people. Yes. You want it to be something where you're moving forward. So we all need to have our eyes on this process and be involved in it.
Right. Thank you so much. I'll segue back to Ms. McCauley, and then we close out with Mr. Earl. Where do we go from here, Ms. McCauley, from where you sit? Because you heard one of the comments we responded to that, came in from YouTube and WhatsApp, where people are questioning, why are we doing this? Why are we making a noise on an issue that is affecting no one? So where do we go from here, based on where you sit?
Well, it's disappointing to get that kind of response, because when I think back to what the kind of information Jet would seek was things like the results of air quality tests, air and water quality tests, public health issues, whether permits had been issued for a particular development to take place in a community. So they were relating to things that most definitely did affect people's lives and their health. So either you support the idea that our government should be open with some important constraints, but should be open, and citizens should be able to access the information that they hold on our behalf, and that there is a constitutional right to get this information, that there is a law that requires certain things of both the person applying and the state agency. If you think all of those things are good and you accept that they are good things, then we need it to work.
Yes.
So I would like to hear the argument that this kind of openness is not a good thing, because I do not think there are any such arguments. Yeah. My involvement goes back before the Access to Information Act, and I can tell you in the early days of JET, we could get nothing out of state agencies. No letter was responded to. No phone call was returned. If you wanted to know what is the air quality near where I live, you could not get it.
So you have to go to the media sometimes to go make noise,
You have to go to the media, and even then, So the Access to Information Act really changed the game for that whole principle of openness and transparency. And I for one, welcome it and think all Jamaicans should welcome it. Sure, yeah. And the only thing I would say about where we go from here is to encourage people to use it, to think about what is it I would like to know from my government that affects me, that does affect me, and then do an API request.
Yes, absolutely. Mr. Earl, where do we go from here, specifically with the tribunal? If you could just repeat perhaps the call for the apology, which we stand with you in that respect as well.
Well, yes, there is definitely the need for an apology, I believe, from the Honorable Minister on behalf of the government as to why it is that this took so long. But I just wanted to touch on what you had raised based on the comments you're getting from some of the listeners. And Section 2 of the Act, makes it very clear as to why we are having this discussion. And it says that the objects of this Act, that's the Access to Information Act, are to reinforce and give further effect to certain fundamental principles underlying the system of constitutional democracy, as you have said, namely A, governmental accountability, B, transparency, and C, public participation in national decision making. So I agree with Mr. McCauley that it's a very sad comment coming from listeners if they are saying, why are we having this discussion? The reason we're having this discussion is because people need to know that they ought to be participating in national decision making, and that they have an excellent tool in the form of this Access to Information Act. And the way the Act is designed is to make information available generally to the public unless it is that there is some applicable exemption that applies in the circumstances. And that is why they say you can make the request in writing, you can make it by way of telephone. I don't even know if some people are aware of that.
Yes,
But
yes.
you can make the application by telephone or other electronic means. So you can do it by email, by WhatsApp. And the idea is that this information ought to be made available. And this is how you hold the public bodies. Remember, this is not for everybody. This is for public authorities. This is how you hold them to account. So it's a critical piece of legislation. Now, I wanted to add that in terms of disposing of these appeals, which are now in backlog, one of the ways in which I believe that can be achieved is by invoking paragraph 2 of the second schedule to the Act, which says, for the hearing of any appeal under this Act, the tribunal may consist of one member sitting alone if the parties to the appeal agree. So remember, the properly constituted appeal body consists of 5 persons.
Yes.
But it's going to be hard for the reasons I indicated earlier in terms of coordination of diaries to get dates heard, especially when you have 20 appeals sitting down. So what I think can be done is if parties agree, the applicant or the appellant, in addition to the state agency, on the other side, that public authority, if they can agree that one person, one of those 5 can sit, doesn't have to be the chairman, you know, any one of the 5 that they agree can sit and make the determination. That, to me, would be a way certainly to fast track and get through these 20 pending appeals.
Yes.
Mind you, when I say 20, that's 20 as at July. I don't know what the number is now.
And
But
we heard Daniel making mention of something that happened before. Ms. Macaulay, sorry, making mention of something that happened before where, you know, there was a whole day process happening by the conference center. So that is also something perhaps that they can look at as they schedule.
Yes. And then one of the other things that I think we need to bring into the equation is this. Why did it happen? How did it fall down in such a bad way? It's bad enough that it fell down, but when it was brought to their attention, nothing was seemingly done. Nothing at all. Why? Is it that there's a genuine commitment to this? Can we really say that that is said with all sincerity, that there is a commitment to openness and transparency and accountability in government? If that is so, then why is it that there is such an inordinate delay? And isn't it so that when your motor vehicle certificate of fitness is going to expire, you don't wait until it has expired before you go to the depot to get the car passed, do you?
Especially in this situation, you can even extend the tenure of those who were seated there.
Exactly, you can reappoint. So you do it beforehand. So if you know, remember, you know, from the day that you appoint the tribunal, you know exactly when their term will expire. It's not a secret from the day you appoint them because it's for a limited time. So once you know that, why then don't you put in place a mechanism that triggers your systems to know that, okay, in 6 months' time, the tenure is going to expire, so let us start looking for the replacement now. Especially as though you have to go to the opposition to get them, you have to consult with them, and then go back to the Governor General. So from 6 months out, if you can do it in 3 months, fine, then do it in 3 months. But you can't wait till the term expires, and then you just sit down, fold your arms, and do nothing. That does not suggest that you are serious about making information known. And that is how you hold people to account.
Yes.
And I wish more Jamaicans would get involved and realize that you don't have to have a law degree. You don't have to have a political science degree. All you need to be is an interested person in the operations of your country. And if that is so, you make your request. They ought to honor your request, and you have a procedure. And if it is not honored, you go to the appellate body,
Yes.
an independent body that can pronounce upon your right to that information. And when people know, you see, we're not looking at the corollary, If it is that the government agencies know that there's no functioning appellate body, what do you think their likely disposition is going to be towards a request from Miss Macaulay, or from Miss Goff, or from Miss Michael Jackson? What do you think is going to happen? They're going to ignore you because they know you can't do anything about it. Because when it gets to the appellate stage, there's no tribunal. So to send a signal, just knowing that they are there, the approach that will be taken to request will be completely different.
So the call would be then, Mr. Earl, thank you so much. Given that apparently the names have been shared with the leader of the opposition, we haven't gotten a timeline. I think we can say our collective call is that they need to provide that timeline, and that timeline must be in short order. Because I can't see the difficulty with not having these names shared publicly and the tribunal duly constituted within 2 weeks' time at least. I don't know.
Precisely. I mean, wasn't it done? Wasn't it done for the Public Services Commission the other day?
But
the other day, with the
Yes.
matter with the DPP. My understanding is that PSC term had run out, that expired, and one was hastily appointed, I think almost on a weekend.
It was on the weekend.
And a decision, yes.
It made public
Friday.
on the weekend and decided on the weekend, and the acting director of public prosecution so appointed on the Monday morning.
Yes, there you go. So when we want to get things done, they can be done. And it's a matter, and remember, this tribunal can be reappointed. So until you decide, okay, we want to have X person on it or Y person, reappoint the former committee. They had one person missing in the form of Professor Ball, Edward Ball, who passed in December last year. So they would need to replace him, obviously, to constitute the 5. Pick that person, put back the other 4, and you have a body of 5, and give them some authority to run, say, for the next year, if it is that you want to change them, or the next 6 months, and renew. But just don't leave us in this vacuum state.
Yeah.
It's wrong, and it is improper, and it is not showing that they are sincere about access to information and the role that plays in terms of transparency, accountability, and good governance.
So agreed. Thank you so much to the 3 guests. That's where we have to leave it. We really do appreciate your different perspectives. Really appreciate it. Thank you so much.
You're welcome. Have a good afternoon.
Same to you all. I see Johnson Beckett making the note that apparently there was a misunderstanding, but I don't know if it's a Mr. or Miss Johnson Beckett. It's not just your comment. Remember, I said that comments in the YouTube here, as well as via WhatsApp. But certainly, how I got it from what you articulated was that this is seemingly a middle class issue where only the middle class persons perhaps had an interest. But your clarification is so noted. All right. Jade, listeners, before we segue into another issue, we need to quickly discuss. Let's put in context. Who does the appointment of the tribunal? It's the Governor General upon the advice of the Prime Minister in consultation with the leader of the opposition. When this type of falling down occurs, I think I've asked this question before, 2 successive weeks.
Yes.
Who do we hold accountable? Because as Mr. Earl rightly reminded us, it was not until that judgment, that ruling coming down from the Supreme Court in the matter regarding Philip Paulwell and the other applicant in the issue of the extension of the term of the DPP and the Auditor General, that we heard on the weekend that there is no Public Service Commission. I want the listeners to appreciate that the PSC is a constitutionally provided body that is there to make appointments of public officials. So we were running around who is the acting DPP because there was no duly constituted PSC. Again, the office of the Governor General, the Prime Minister, and the leader of the opposition all had role to play in that respect. And here we come now to the ATI Tribunal, and it's the same issue. And just to indicate to the listeners, JFJ also wrote to the office of the Governor General and the office of the Prime Minister, copying, of course, the Minister of Information on the matter of the ATI Tribunal. And we did that because they do have a constitutional role to play in some of these matters, the PSC, but here a statutory role to play in the matter of the ATI Tribunal. And though we recognize parliamentary sovereignty where the Governor General is concerned, I can't see that we are paying a body and there seems to be no, I'm supposed to sign off on something, but I don't know what. I'm not checking the timeline. And the office of the Prime Minister, more so, ought to be held to responsible in this respect. Because as we explained earlier, this is a constitutional right that we have. The media has a right as well to seek information, to disseminate. And in the absence of a duly constituted tribunal, our rights, as far as we're concerned, is being undermined. So, I just felt that was important to put in context. Yeah. I know we had another matter we wanted to quickly touch on, Jade. The Tracy Robinson article following her speech recently, and she's now an appointed professor.
Yes.
So we extend our congratulations to Tracy Robinson, human rights attorney.
Yes.
For those of you who passed through law school.
Yes, a previous lecturer.
Yes.
And a great one at that.
A great one.
Yes.
And she is such a good person to know when you're talking about human rights matters. And the Gleaner covered aspects of her speech recently. And, it's food for thought for all of us. What we mean by decolonization in terms of severing the ties with our former colonizer, the United Kingdom, because we still have the Privy Council, and that's a touchy issue. But, our stance here is it's the Caribbean Court of Justice ought to be acceded to. So you have the Privy Council, you have the monarchy still remaining as our head of state, and kudos, I think for the most part we want to get rid of that arrangement, but it's just a matter of what we're replacing it with perhaps, and the how that is still of contention. But the third aspect, which was one of the reasons for my being missing from the show a few weeks ago, when I was at a conference discussing this very matter, we have so many archaic laws that criminalize, let me use proper English here, Westwood High School will be so disappointed. Criminalize poor people, criminalize the homeless, laws that remain on our book that the British have changed. And, Professor...
And that we haven't reviewed in many decades. So
it's something for us to really look at. How do we get rid of these archaic laws? 1861 legislation, but we're still using it. We really do need to one day look at some of these pieces of legislation to say, how are these archaic laws undermining some of our fundamental rights and putting vulnerable people at risk? So I was quite happy when Professor Robinson touched on that particular issue, because it's something, a little pet project. I said I needed to do something on that in that respect. Archaic laws that need to be gotten rid of.
Yeah, for sure. I can agree with that. All right.
And I hope
so,
you'll join me in that project. So it's not a JFJ paid
well,
one.
to be fair, I have done a little bit on it before because I remember looking at the town and communities a few years back and picking out subsections that I was, even as a young law student, shocked that we still had these kind of provisions.
The 1898 OBIA Act.
Yeah, no, that one was jarring. But we did have a winner for a trivia question, news commentator. Thank you for coming back this week. We missed you last week.
It's Miss Kimmy from Instagram.
No, that's I got a message.
And news commentator, she's at a meeting, but still winning trivia.
Yes, but my producer said it was news commentator. So if that changes, I'll be sure to let you guys know.
I was just being cheeky.
News commentator, congrats. The review period is 2 years after the implementation of the legislation, and the legislation was implemented from 2002. So
and not amended since.
No.
But in at least 2 throne speeches, we heard that it will be amended.
Yes.
In at least 2.
Yeah.
Yeah.
But yes, so news commentator, you can reach out to 2397583. But I think at this point we can reach out to you, so you'll get your prize. But we're at the end of the show. Thank you for joining us. I'm Jade Williams.
And I'm Michael Jackson. Have a good Monday.
Jamaicans, for justice, the people's champion. Justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Out of many, we are one in a Jamaica. Make it a better place for the boys and girls. Created equal by the creator. For equal rights and opportunities. No to unlawful detention and police brutalization. Class, gender, race or religion. We not tolerate discrimination.
To join the fight against injustice, contact us at 755-4524 or JamaicансForJustice.org.
The people's champion.
JP said me is banana chips. 20% more chips in the banana left on ground. The time by JP said Mare's banana chips is
201.
You're invited to the Info Exchange Cloud Forum